Hello and good afternoon, everybody. It's terrific to be with you on the 21st of March. It is spring, believe it, we made it, and things are beginning to blossom. Really looking forward to sharing this next season with you, and of course, the 45 minutes that we have together this afternoon. If you would turn to the next slide, please, Kathy, I'll walk the group through our agenda. Thanks in advance. There it is. What I'll be covering are the topics I typically address at the beginning of the program, including what's going on in public health. And there's plenty, of course, happening in New York State with the budget, and we'll give you a quick update there. Then Frank Patty will be with us to talk about an unusual, indeed first of its kind acquisition, in higher education. So Frank, thank you for joining the program for the first time, and with any luck, it won't be the last. Mark Bellaborodov is back. Mark, as you're familiar, is a seasoned intellectual property attorney and who's going to be spending some time discussing essentially AI and the various legal permutations of this developing technology, which we know is really everywhere at this point. Mario Ayub is back as well out of our Buffalo office, and he'll be addressing website accessibility requirements with an eye on the ADA. And I'll be closing out the program along with Adam Mastroleo, more on that a little bit later. But for now, let me turn to the content I'll be covering. If Kathy, you'd please advance the slides, that's great, thank you. And what we know right now is that in the Senate as well, the Assembly in Albany, those one House bills have gotten out, and essentially what that will do is really lay the groundwork for the negotiations that are already, very much underway. In fact, there are going to be big gatherings in Albany today around issues like home health care and its funding. We know that the Assembly and the Senate have folded into their proposals additional monies for hospitals, for nursing homes. There's transformation funding and capital funding. All of that is part of the usual give and take that we'll see as we move toward April 1st, which is the day by which the budget ostensibly is due and needs to be signed into law. More on that in a moment. Commissioner Bassett, I should know, former Commissioner Bassett of the state's health department, has actually stepped in to provide her voice on her support for coverage of the uninsured. So lots of different constituencies and individuals wishing to offer their opinions of what's important in this budget, which of course is, about as central to the state's policy as one can get in terms of how our tax dollars are expended. So more on that as it continues to sharpen. Next slide, please, Kathy. And I wanted to also note that, of course, healthcare isn't the only issue in the budget. It happens to be the area where I spend more of my time in terms of my practice, but other issues that are very much on the table include housing. The governor had a very ambitious and significant proposal around housing that got its start in her State of the State. The Assembly and Senate have pared that back considerably if their versions were to be signed into law. There's a lot of discussion around what bail reform should look like, if at all. Environmental reform, much the same. The Metropolitan Transit Authority, which of course gets everyone everywhere in New York City, and it has other emanations. It's a lot of money at stake, and in our post-pandemic environment, lots of discussion about what the future holds there. Open question is whether the budget is going to slip past April 1st as a general matter. That hasn't happened all that often in the last decade or so. Former Governor Andrew Cuomo, was very focused on on-time budgets. Some of his predecessors were more so focused on the content of the budget, and sometimes things would slip a bit, as it were. Governor Hochul has given indications that she wants a budget ultimately that is well negotiated, and so we'll be tracking to see what we have on April 1st. And their technical means of kind of keeping the government open, essentially, if there isn't an active budget, we'll rely on the one that's in place right now and just extend it a bit. But that's all to come, so we'll keep tabs on that for you. Next slide, please. So let's move to public health, just a couple quick ones here. And this is a big one for all of us, again, involved in healthcare and its surrounds, let alone, what really was a national story for, much of the pandemic. Nursing homes, of course, were very much at the epicenter of, where unfortunately the morbidity and mortality centered throughout, particularly the early days of the pandemic, and there were restrictions all across the country, including in New York, in terms of how individuals came to and from nursing homes. A big one just got lifted as of last Friday. Negative tests are no longer required to enter a nursing home, which represents a sea change of sorts. It's bringing New York into alignment with federal policy, but just one other sign that we're moving into a endemic or post-pandemic, pick your phrase, environment in terms of our policy and otherwise the kinds of restrictions in place. Next slide, please. And all of you have certainly come to appreciate that there are treatments in place now if you do happen to have a COVID-19 infection. And one of the key ones is Paxlovid, which has been provided, essentially through governmental contract under emergency use authorization. There is a recommendation by an influential panel that guides the FDA to essentially allow that to go to market in an ongoing permanent posture. We'll know more about that in May, but that speaks, or thereabouts, but that speaks to the nature of our shifting dynamics relative to the pandemic once again. Next slide, please. And so finally, as well, I just wanted to note that in New York State, telehealth is, of course, is an element of the way that healthcare has changed, arguably forever, and the way in which practitioners and patients connect is, as far as New York State is concerned, with the Medicaid program, still going to be in this new and more flexible posture in the Medicaid funded environment anyway. And details exactly what that looks like are now out. The Department of Health issued them earlier this month. And I just raised it again as another marker of, in our changed world, some things are here to stay, some things are really being cemented. And this is one of them, an important one that we'll be tracking for all of you. So let's go to the next slide, please. And that gives me an opportunity to introduce our next speaker. As I mentioned, Frank is new to the program, but of course, not new to those of you who have been trusting Frank for many years, since he's been with Bond. And Frank is someone who brings a deep amount of educationally oriented legal experience out of our Syracuse office, and is going to be addressing a first of its kind acquisition in higher education. Frank, I'm really glad that you could join the webinar today. Thank you so much for your time. Frank Patchy, the floor is yours.
Thank you. Thank you. So thank you everyone for joining us today. I wanted to talk a little bit here about an acquisition that I had recently worked on. But first, I want to kind of contextualize it. I know some of the people who are participating today and watching this are in the higher ed arena, but many of the things that we're going to be talking about here would apply to healthcare as well, and basically to any area that's under significant stress. Kathy, next slide, please. So I think, the higher ed area in this sense is a canary in the coal mine, with respect to what's going on. And I thought I'd paint the picture of that first for those of you who are not familiar. So in 2008, we had the Great Recession, and that had a dramatic impact on where we're headed now with higher education, insofar as it had a huge decline in birth rates. The consequence of this right now is that the number of 18-year-olds will be declining by 15% beginning in 2025. And that's, just an enormous number. Imagine, in any industry, if 15% of your consumers just disappeared overnight. Declines will be even more substantial in the Northeast and the Midwest due to migration. In the Northeast and the Midwest, We have people leaving for various reasons, moving south, and so forth, and that exacerbates this 15% that's on top of this issue. Additionally, we have a booming labor market, which is putting additional stress on enrollment as the students confront a market that, at least for the time being, may not justify the cost of degrees. There are situations in technology companies where the only skill set necessary is to be very intelligent and to know how to do coding. And even very prominent companies like Google and Microsoft and others have foregone, in many instances, what would have been in the past a traditional requirement for a degree with respect to those people, and pay them very well. Additionally, even in the manual labor sector, we see situations where there's a huge shortage, and employees have one situation that I'm thinking of right now where a construction company down in the New York City area has offered $48 an hour to start for somebody right out of high school if they just go through a quick manual training program. Additionally, this is independent of the rest of it, there's been a decline in the stock market. So the investments that many institutions rely on are no longer generating the income that they depend on. And then, making that matter even worse, we have a very high level of inflation that's adding additional stress in these times. So we have the makings of the perfect storm. Many of these institutions have also, over the years, because of competition, been forced to effectively expand their campuses, even when enrollment was the same or even going down, to keep up with the Joneses. So they've taken on, in many cases, very significant debt to build additional buildings and so forth, where their enrollment has already been declining, and now that adds further to the stress. Kathy, if you could change the slide, please. So in this area, as you can imagine, it's very important to be proactive for these institutions before it's too late. So we already know from the demographics what's coming up. And if we waited, then, to do something, then it could be that it precludes us from taking the necessary action, because other institutions particularly are also going to be in the same. So it makes sense, for institutions that at first blush would think that, this is an issue coming to them, to take a close look at this and identify the problem, the magnitude of the problem, the projections and everything, so that they can gauge where they stand. And once they have a good understanding of where they expect to be, let's say in 2025, 26, 27, 28, given these circumstances, then it should inform both the need to act, but also the magnitude of what they need to do. So Kathy, if you could switch to the next slide, please. There are several different actions that could take place. So this is the important part of what we did recently, the transaction that I was involved in. Among the choices, obviously, would be cost cutting. So that, maybe you have items that should have been cut a while ago, but due to inertia, whatever, they were not. And a good look at those, makes sense anytime, but particularly at a time like this. But then you have to question, what cost cutting is responsible and what cost cutting can be problematic, right? So in some instances with higher educational institutions, we have legacy programs that, for example, very few people take any longer. They are not in the contemporary world in high demand, and they're losers, economically, financially. Those types of programs may make sense to cut, but sometimes those programs are also heavily supported by alumni. So the reality is you could cut the program, but then you're also potentially cutting support from alumni going forward. Other programs, may result in then even less enrollment and have collateral damage that brings with it. Some instances I worked in, the sports programs were cut. Well, you may lose significant students doing that, or it wasn't taken into consideration the overall impact of discontinuing a program that would have on other fees and room and board that goes along with it when those students no longer attend there. So another option is increasing revenue by increasing enrollment. So revenue, the concept independently could be that we're going to reduce, we're going to increase the tuition, or we're going to reduce the amount that we charge, net. So factoring in student financial aid and so forth. That becomes a very difficult thing to do because everybody's doing this right now. Everybody's looking at, in this environment with inflation and everything else, how do we stabilize or increase enrollment and increase revenue, net. So that's something that everybody's doing. I think the expectation that you're going to address that issue and come out ahead, I think is going to be very difficult, that proposition to do that when everybody's doing the same thing. So I think that one's tough. Affiliations with other institutions. These are an area that I think if you're going to proceed with these strategic relationships, strategic partnerships, then it behooves you to start that as soon as possible if you expect to come to fruition, because they're very difficult. Institutions, higher educational institutions generally are very independent, and the proposition that they would be ceding some level of operational control or management control over any function because they're affiliating with another institution is a very heavy lift for boards particularly, but for everybody else as well, including the alumni, who can sometimes have a backlash against it to overcome. So I think if this makes sense to do, by all means, if this is in the realm of possibility, I think it merits pursuing shared services organizations, affiliations, this type of thing. But just be aware that you need to get a major head start on these, and don't expect that every opportunity will come to fruition. My experience has been it's very difficult to do this. So where you come out of the gate with some high expectations, they can be deflated shortly thereafter as you get deeper into the weeds. So then the next one is mergers and consolidations, and that's what kind of precipitated this presentation today. This is another one this solution could result in a great outcome. Merger and consolidation, I think those two kind of speak for themselves as two institutions or three or what have you coming together and becoming one, and economies of scale, eliminating redundancies, all that stuff hopefully will be the net result of that, and you'll come out with a much stronger institution. The transaction that I referenced earlier, that is one in which a private institution decided that they wanted to do something like this, but they realized that timing-wise and so forth, it was very difficult. It was going to be a long-term effort. So what they did was they looked at proprietary for-profit institutions that were for sale, and they identified one that was ideal, and they've entered into a purchase agreement for that. So that way, it eliminates some of the issues also, right, with respect to the target automatically accepts that in this case, that they will be giving up their autonomy and so forth to a degree. So that issue of two entities coming together is somewhat alleviated and can be done on a faster speed. So the final area that, the option, unfortunately, is closure. And that is one that we're seeing more of. I'm working on two of them actually right now. That sometimes, unfortunately, is the outcome of these where the other solutions don't exist or haven't been able to be achieved in time. But because of regulatory issues and so forth, closing a higher educational institution also requires significant advanced planning. It's just, I analogize it to closing, for example, a nursing home or a hospital. You can't just do that tomorrow. What happens to the people that reside there? what happens to people that rely on that? So students, same way, you're not supposed to just put them out on the street. So if you're going to close, then that's also something I think, an academic year in advance is a good way of doing it so that it can create as soft of a landing as possible for all the parties involved. So with that, I have come to the end of my presentation. Thank you.
Frank, thank you. Really appreciate the opportunity to learn with you about these fascinating dynamics relating to institutions of higher education and some of the creative solutions out there that you're guiding these institutions to consider, and looking forward to having you back on the program in a future instance. In the meanwhile, let's shift to our next speaker for the afternoon, and that is Mark Beloborodov. And Mark, as all of you are likely familiar, has been on the program before and brings a career's worth of intellectual property, both in-house and otherwise, as someone concerned about questions of policy, and has brought that with him to Bond. And so what Mark is here to discuss today is whether AI can invent, create, or infringe in legal context. But Mark, I'll let you explain further what you intend to address this afternoon, and we're delighted that you're back on the program. Thank you.
Of course. Gabriel, thank you for having me come back. And hi, everybody. So when Gabriel asked me to pick a topic, what's new in the AP world for this webinar, of course, I went to my trusted advisor, the ChatGPT, and I got the response, why don't you talk about me? Let's talk about AI and what's happening in the world of AI on the IP side. And actually, a lot is going on right now. So next slide, please. So what is AI? Many definitions exist. I like this one. It's a branch of computer science that aims to create systems that behave using skills commonly thought of part of human intelligence, ability to think, learn, and act. Of course, it is not new. AI has been around since 50s, but what is happening now is, first of all, there is a avalanche of growth of technologies that enable AI, data, storage, computing power, connectivity, algorithms, as well as there is a real need to use AI to advance business objectives, image analytics, pattern recognition and advice, and most recently, new content generation. Next slide, please. And just in a past few years, there's been so many companies that are active and quite successful in creating content using AI, text, video, image, computer code, speech. Sequoia Capital, a VC outfit, put this together. It's quite remarkable. Many of these companies you probably heard and probably even using. But there's really so much started to happen in a really just few years. Next slide, please. So before we switch to the question at hand about IP aspect, just very super brief 30-second primer. This is the architecture of any kind of AI engine. And simply put, machine learning, that is part of AI environment, is a form of data analysis where algorithms that continuously learn from data, computers could recognize hidden patterns without being programmed to do so and produce output. And as models exposed to new data, they kind of self-adapt to produce reliable and more consistent output. Importantly, no matter what the kind of learning mechanism is, all AI engines require amount of data to help it learn, and that is called training data. And more and better training data is, the better AI solution ultimately would be. Just like the finest meals begins with best ingredients, so the finest AI comes from best and voluminous data. Next slide, please. So, can AI be an inventor or an author? Lawyers, we always go back to the Constitution. And as I already talked about this in my last presentation, there is a Article 1, Section 8 IP clause that talks about IP is being part of the framework of this country. And so Congress has the power to award exclusive rights in writings and discoveries to authors and inventors. So can AI be an author or an inventor? Let's find out. Next slide, please. So Patent Act, it talks a lot about individuals. In a definition section, in a section 101, it's about whoever, an individual, and there's a lot of references to individuals and their obligations as inventors. So it's quite clear, you would say, that AI ain't it. Not so fast. Next slide, please. Enter Davos. Stephen Taylor, you see his picture here on the slide, is a evangelist and a big fan of AI technology. He's a scientist and engineer. He founded a company called Imagination Engines to develop AI technologies and to push the envelope of legal rights that AI could have. And so he filed a couple of patent applications on inventions that his AI engine came up with. One you see on the screen, the other I omitted for the sake of time. This is a container with this protruding flexible elements that could improve stacking, kind of connecting those containers and their visual appeal. Okay. US Patent Office denied the application because Stephen could not produce a declaration from the inventor. And notably, he was quite transparent about the inventor being the machine, not being a human. The USPTO rejected the application because he could not produce the declaration of the inventor. He appealed to Federal Circuit. And luckily, judges did not go into whether AI engine is kind of sentient enough to make statements and really make a declaration, but really, does the statute mean what it says? And they ruled that yes, statute talk about individuals, and those individuals are humans. Kind of same outcome. Stephen pushed this in Europe, in Germany, and the UK, in Australia, and other countries. Same outcome except South Africa. In the UK, he got the acknowledgement that AI can be a creator. So what remains to be seen going forward is what happens when there is kind of a co-inventorship with the engineers who can create a solution really working with AI and really contribute to the invention. That remains to be seen. But for now, AIs cannot be inventors. Next slide, please. Well, what about authorship? What about copyright? So interestingly enough, this is not the first time that this issue came up. Kind of the IP world addressed creation by non-humans on the legal side. About 10 years ago, a photographer left his camera in the woods on a shoot, and the monkey took a selfie. Photographer put that selfie into his book, and PETA sued on behalf of the monkey. And the Court of Appeals from Ninth Circuit ruled that monkey doesn't have a standing, cannot sue under Copyright Act. Next slide, please. And again, in 2018, enter Davos. Using the same engine, Stephen Taylor filed for registration for this beautiful artwork that his engine came up with. And Copyright Office was caught unprepared. They really couldn't decisively reject the application. It went through 2 years of consideration, and then on appeal, next slide, please. On appeal, they ruled that yes, the authorship needs to be human. Stephen Taylor tried to argue that it's not constitutional. That did not go far. And so that was the end of last year, February of last year. Ever since, there's been an explosion of artwork created using AI. On your left, you see a DALL-E engine by OpenAI, where the prompts talk about robots holding scales of justice, a robot painter with flowers, a robot learning the law, and AI engine creates these kind of images. Now they're everywhere. On your right, interestingly, you see a comic book generated entirely using AI, a different engine called Midjourney. And the author also wanted to push the envelope. Her name is Chris Kashtanova. She applied for copyright and she received copyright registration for this comic book last November. In February, it was revoked in part. So the images generated using AI, again, weren't made by a human author, although the arrangement and the storyline was protectable. So that is kind of interesting. Anticipating an avalanche of comic books like this and this issue, next slide, please. The Copyright Office has spoken and issued a policy proclamation explaining that there really needs to be a human authorship and AI cannot be an author in a way that is currently being done through prompts and images. So in other words, you cannot think art into existence. You really need to do the work and express your idea. So again, what's left open is what happens when the artist works together with AI, for example, in post-production using Photoshop, does something with images, like really adds creativity to it. We'll see how that goes. This is very recent. This policy proclamation came out 3 weeks ago. So we're really talking about very, very hot issue. Next slide. So my time is almost up, and this is kind of the best part. And with any new technology, think back to Napster. I'm dating myself. But the first of its kind lawsuits just begun. There's 3 lawsuits currently pending for infringing copyrights. One lawsuit is a proposed class action filed in California against GitHub, a depository of computer code. It's a company owned by Microsoft. And the issue there is when AI helps programmers generate computer code as they type their programs using a GitHub tool called Copilot. There is literal copying. There are snippets of computer code being added to the product by the user without any attribution or license required by open source licenses of this computer code. So it's a very interesting case. It just begun. We'll see where that goes. So we're talking about computer code. Next, January of this year, 3 artists sued three most popular art generation AI engines, alleging that they are infringing rights of millions of artists by using artwork by those artists as training data to train their AI tools to create art. And you see on your right on a screen. So those art images are scraped from the web without knowledge or consent of the artists, and that's infringement of copyright. Again, just filed in 2023. Slightly different flavor of a similar suit filed by Getty Images against Stability, accusing that engine of using just Getty collection, and sometimes even creating some kind of a derivative use, some kind of a AI version of Getty collection images, as you see on your right, again, without authorization. So that's my, so my last slide. Next, please. And the question is, really, do we have copying here? It's an open question. How to prove that copying actually happened with training data? And second, recall fair use discussion we had last time. In a Prince case, isn't using these images to create those new kinds of images is protectable, sufficient, fair use? Remains to be seen. This is happening right as we speak. We'll see how that develops. Thank you.
Mark, that was terrific. And I knew what Napster was when you referenced it, so maybe that dates us both. But this is really fascinating, and where this all goes, I know this audience will be interested in monitoring, and so please come back and share your observations in the future. For now, though, let me shift to our last speaker today. It's going to be Mario Ayub, who is back with us from Buffalo. And Mario's ready to discuss ADA relating issues concerning website accessibility. This is very topical. There's a lot to chew through here. Mario's going to give us the highlights, and Mario, thank you in advance.
Thanks, Gabe. Thanks for having me back, and thank you everyone for sharing your lunch hour with us. I can't promise I'm going to be as interesting as robot painters. It's kind of a tough act to follow, but I'll do my best. If we can go to the next slide, please. So before we get into what website accessibility is and what it looks like and what it doesn't look like, I just wanted to take a quick step back to look at the underlying law that is underlying a lot of the lawsuits that are originating from accessibility issues, and that's the Americans with Disability Act, specifically Title III. Title III governs public accommodations, so it prohibits discrimination against people with disabilities in any place of a public accommodation. So restaurants, hotels, parks, any public space offering services generally to the public, that's going to count. Interestingly, there's no reference to websites in the language of the ADA in this particular section. But as you'll see throughout this presentation, courts have started to recognize that it doesn't just apply to brick and mortar buildings, it also applies to websites who are offering services. And of course, the ADA does not offer any concrete recommendations for website compliance, obviously because they were not contemplated at the time of drafting. If you could go to the next slide, please. So finally, in March 2022, I believe it was March 18th, the DOJ released some guidelines examining what accessibility looks like in the context of the ADA. And right off the bat, they made it very clear that their interpretation of the law includes websites. So the gray area here is rapidly disappearing. Courts and the DOJ, the governing body charged with enforcing the ADA, there's no more guesswork. It applies to websites. So while the guidance doesn't really offer any concrete steps to take, they do offer a list of what doesn't constitute accessibility, what looks bad from a regulator's point of view. So we're looking at things like poor color contrast. Maybe someone has difficulty perceiving colors. Is it too difficult to try to read the text on the web page? Reliance on color, again, to provide information. That could be with images or text. Lack of text alternatives or alt text on images. So a lot of text to speech or text to audio accessibility tools will read the image description to the user because we cannot obviously translate the image itself. No captions on videos, those with either language barriers or auditory problems, inaccessible online forms, and mouse-only navigation. Again, that's contemplating people with any movement restrictions who are unable to operate a mouse. We want to still be able to have their ability to navigate the website and to gain access to publicly available services. If you go to the next slide, please. So again, no concrete prescriptive measures for bringing your website in line with the ADA's mandates for accessibility, but the DOJ does point us in the direction of two very helpful resources. The first is the Web Content Accessibility Guidelines. You most often, if you've seen this, if you've come across this at all, you've seen the abbreviation WCAG. I think we're on the second iteration of that right now, and the third one is being developed. And it's a set of principles and standards for building a website with these accessibility measures in mind. And then second is Section 508, the standards that are laid out in the Rehabilitation Act. This act applies to federal government websites, but it can still be used as a resource when a private company is designing a website. They borrow a lot from the WCAG, but it's still definitely good to take a look at both, because while some of the same principles are applied across both standards, they're worded differently. And if you're going through line by line trying to measure your website against the standards, maybe that different wording will kind of spark a new discovery on your website that you might not have otherwise seen with the other standard. So if you can go to the next slide, please. So looking at the WCAG really quickly, there are multiple prescriptive measures that you can take to bring your website into compliance with accessibility expectations, but they are organized around 4 foundational principles. So the first is perceivable. So for people with any issues with perception, vision, hearing, there has to be a way for the user to get the information off the website. It has to be perceivable across many different groups of people with different restrictions. It has to be operable. Again, this is talking maybe a little bit about the mouse and keyboard or any mobility issues, but the user has to be able to, regardless of their physical condition, should be able to move around the website with ease, depending on what restrictions they may have. Understandable. So there should be text to audio where applicable. There must be subtitles where applicable. It has to be understandable to any user that comes across the website. And robust. This is a big one because it often gets missed. Here we're looking at plugins or back-end features that allow assistive technologies that may be installed on the user's device to play seamlessly with the website. So if they have an audio program, or if they have a voice-to-text program where they can type into a website, your website needs to be ready to accept those assistive technologies so that they can plug right in and use the website seamlessly. If you go to the next slide, please. So I'm not going to spend too much time on section 508 because a lot of it is the same. Like I did say, I think it is very important to go back and take a look at both as they phrase things differently. Again, it's for federal agencies, but it's definitely worth a look. Some of the standards that are pretty popular: text equivalent for every non-text element. Again, color perception, they must be presentable with or without color. So black and white, grayscale, and color. There shouldn't be any difficulty determining it if you maybe have difficulty perceiving color. Documents must be readable without requiring a style sheet. So any downloadable documents or attachments that you might offer on your website has to be easy to navigate and use. And rows and column headers must be included for all data tables. A lot of these are common sense, but they're easy to miss when you run, especially when you run a complicated website with many download points, attachments. So it's good to have a list that these 2 standards provide to go through and walk through your website to make sure you're in compliance. If you could go to the next slide, please. So why do we care? I guess this is not the point of the presentation to scare anyone, but this is a good point to look at the rise in litigation based on this Title III, where litigants are suing private companies saying that their websites aren't accessible. Maybe they had trouble reading it. Maybe they couldn't use their voice to text or text to audio for listening. And if you look at the chart on the left here, you'll see New York is in second place with these Title III federal lawsuits. And the chart on the right is a good indicator of how these are growing, how these lawsuits continue to rise every year. It's becoming more and more popular. Their target, some litigants are targeting smaller or larger businesses. It doesn't really matter. We're seeing it across a variety of different industries and a variety of different sized industries. So these trends are important to keep in mind as we go forward. If you could go to the next slide, please. So just a few key takeaways. At least annually, you should be looking at your website, looking at the free resources that these frameworks, the WCAG and Section 508 provide. They're very accessible to anyone online. You can look them up and start to run through the lists and see where your website measures up. But you also need to be able to know when to bring in outside help with compliance. There are a variety of different service providers that can help with the back-end issues that I was mentioning, plugins for accessibility software, some of the stuff you wouldn't notice just looking at the web page. That is oftentimes the target of some of these complaints and lawsuits, stuff that's not visible to the naked eye. So if you were looking at your website, everything looks readable, the colors, there's multiple options for colors. Any of the obvious stuff could be in place, but if it's still missing some of the back-end software that would allow people to plug in their accessibility software, you're going to run into some issues. And if your website's not in compliance, you should move quickly. because there are plaintiff firms and other organizations that are doing automated scans of websites on a daily basis, looking to identify websites where they have not been up on their compliance. So if you do notice something right away, it's time to act as soon as possible. So that's just a brief high-level overview. If you have any additional questions, feel free to email me. I'll get back to you as soon as I can. Thanks, Gabe.
Thank you very much, Mario. And we don't have a final presenter beyond Mario, but I do have a final point I'd like to make. And I'm delighted that Adam, who normally is on alternating weeks with me, is here today, because Adam is going to be stepping away from co-hosting duties. Adam, of course, has been with you for many moons, walking you through on Tuesday afternoons. And we wanted to share the news with you today. Kristen Smith, who couldn't join us this afternoon, will be beginning her co-hosting duties, next week. She's known to many of you. She was with Bond for a considerable amount of time before going to the city of Syracuse, where she served and then returned to Bond. And she'll be bringing leadership to this program from the Syracuse office. And we're delighted that Kristen has agreed to take on this role. But Adam, we really just wanted to take this moment to thank you, to let the audience know just how much we appreciate all that you've given over your tenure in the seat. And I wanted to give you an opportunity for a few words.
Gabe, thanks so much. And I do want to sincerely thank everyone who's attended over the past 2 years that I've been one of the moderators for this program. We really enjoy putting this program on for you. I know all of the presenters like to present at this webinar. I will say that we really appreciate it when you provide us with feedback. Let us know topics that you find interesting or would like to hear more about. So please continue to do that. I look forward to continuing to participate in the webinar as a presenter at some point in the future. But thank you again for being here. We look forward to seeing you, and you're in great hands with Kristen.
Thank you so much, Adam. And we very much look forward to having you back on the webinar whenever you have content that you wish to bring forward. And thank you for all of your service to Bond's clients. And we will do our best to carry on the program in the spirit that you've set forth for us. So for all of you who have questions and follow-up, those email addresses you see on the screen are the ways you can reach today's various presenters. And please look to Kristen to lead you through next Tuesday. I'll be back with you when we flip the calendar into April. And in the meanwhile, I'm wishing you all a terrific afternoon and a wonderful start to spring. Thank you.